Defamation 101, brought to you by Lindsey, Kadi, and Cory.
Defamation is a defamatory statement. This is a false statement about a person to their discredit. It is also a statement that tends to lower a person in the estimation of right-thinking persons in society generally. This could involve accusing someone of doing something that is shameful, of having a dishonest character, or carrying an infectious disease. Defamation is not a statement that enhances someone in the eyes of others, and it also does not attribute good qualities or actions to a person. Innuendo is when the audience is in possession of additional facts that makes a statement defamatory. Defamation must be intentional, which means that the words constitute a willful act, and it must be about a specific person or persons. If a statement is not published, it is not defamation. Publication means that the statement must be made to someone other than the one that is being defamed. Anyone who participates in the publication of a defamatory statement can be liable in tort for it.
There are two types of defamation, libel and slander. Libel is written or otherwise visually communicated, whereas slander is oral communication. The main difference between the two is that libel is actionable per se and does not require proof of special damages, whereas slander does need that proof. This means that a person suing for libel does not have to establish that specific expenses have incurred, but with slander you must be able to quantify the loss. There are certain exceptions to this rule, and these exceptions are treated as slander. Defamation in the media. There are two competing interests that are being protected. There is the tradition of freedom of expression and an attempt to protect people from unwarranted harm to their reputations. In the US, this balance is simple because you are protected because their constitution guarantees the freedom of the press. Whereas in Canada, the media is considered a person or corporation and do not have special privileges against defamation.
There are a few defenses for defamation, but a mistake is not one of them. If you thought that a statement was true, but ended up being false, and even if you can prove that you believed it was real, it is still not a defense for defamation. However, if you are telling the truth, you can use it as a defense. If the report is accurate, even if it discredits the person being described and of no public benefit, it is not actionable as defamation. The obligation of establishing the truth falls on the defendant, not the plaintiff. This may be very difficult, and if the attempt is made at trial to prove the statement is true and the attempt is unsuccessful, then it will likely damage the case and make the award greater. There are two major defenses, privilege and fair comment. Absolute privilege is limited to court proceedings, including the trial, pleadings, and processes. There are no circumstances where the level of government official can be sued for defamation. This also goes for conversations between husband and wife, and lawyer and client. Absolute means that you're protected no matter your motive. Qualified privilege is when there are special circumstances that allow you to not be sued for defamation. Some examples of this are employee reviews, self-defense against attacks, or a review of marks. The statement must have been made honestly for proper reason, without malice. The statement can only be spread to those who need to know and can only be made available to those who need to know. Fair comment is when someone does something for public interest and is subject to criticism and comment. These must be stated in the way of an opinion and not fact. The comments cannot be unreasonable. If there are facts presented, it can be found as defamatory.
In 2015, there was a case of defamation in which Deborah Duez sued Facebook for using a photo of her in one of their suggested pages that suggests that she had herpes.
Place your head on my beating heart.